Good morning. Thank you for joining us for this edition of Ask CAMFT. The topic on the table is telehealth, but that's a pretty big subject. So I think what I'd like to do is sort of winnow it down to an issue that there's been a lot of, I think, misinformation about out there. So this would be a good chance to sort of clarify our thinking on a key issue. One of the issues with telehealth is, can we do it across state lines? And I think the short answer to that one is always going to be no, because you don't have a license in the other state. Right now, there is an exception in the federal law that would allow employees of certain federal agencies to do telehealth across state lines, but that exception is only for federal agencies. It's not a broad exception for licensed clinicians. Right now, the psychologists are working on sort of state compacts that would allow more flexibility with these sorts of issues, but that's probably going to be a few years down the road. So right now, we got to think very carefully about doing teletherapy across state lines. I know there's a case right now in the BBS accusation that the BBS was not happy that a clinician wrote an emotional support animal for a letter for a resident from Pennsylvania. So they felt that was practicing. So we want to stay inside of California in terms of doing telehealth. The other issue, though, is what happens if a patient travels for work or for vacation. And right now, there is a few cases that are on the books that would seem to sanction that as an okay thing to do. It's sort of what's called temporary follow-up communication doctrine. One of these cases dates back to 1972, the Wright versus Yackley case, but they've never completely forbidden any sort of follow-up care by physicians with their patients. In fact, they think that not following up would actually be a violation of the standard of care because of the abandonment issues. So the Wright case, I think, is a really important one to understand going forward, and it involved a doctor-patient relationship in, I think it was South Dakota, but then the patient moved to Idaho, but needed some information from the doctor about a prescription, basically needed a prescription refill. So the South Dakota doctor refilled the prescription for the Idaho resident now, and then something contradictions with the prescription. The Idaho resident is trying to sue the South Dakota doctor in Idaho, but the Idaho court said that the lawsuit couldn't go forward in Idaho because all the doctor did was provide follow-up care communication with the former patient. So we think this is a new issue, but it's really not. The issue's been around many, many, many years. Think to folks in the Midwest where a river may separate, states, and doctors have always had this challenge of, what do we do with a patient that, comes to our side of the state for medical care, but then, goes back home. So it's interesting though, but crossing state lines tends to create three types of issues. People are continually joining in. Again, welcome to all of you. Looks like my good friend Ernesto Segusamundo is joined us, and glad of him to take part from his very busy day. Teaching, practicing, and video recording therapist. So big shout out to Ernesto. Anyways, we cross state lines. There's like three complications that tend to pop up. One of them is, where would any subsequent lawsuit be heard? Would it be in the clinician state or in the patient's new state? And as long as the clinician's sort of interaction with the new state is fairly passive, then they're not going to be able to sue you in their new state. They would have to come to the old state and sue you, which helps us because we wouldn't want to defend ourselves in the other jurisdiction. So that is one risk, though, of seeing somebody that crosses state lines is I might actually have to defend my conduct in another state. The deep issue with that one is going to be how much purposeful contact did you have with the foreign state. Marketing, in another state is going to be a key factor, as well as rendering services across state lines. The second problem is the criminal component. All states have licensing laws. That's why you guys had to get licensed, and nobody can do marriage family therapy in California, unless they're licensed or working in some exempt setting. So states do take this seriously. They do prosecute these cases. Same for lawyers. I can't go to another jurisdiction and just open up a practice. I'd have to get cleared, by the other state. The most important case in this area is the HAMAS case that dates back 10 years or so, in which a Colorado doctor prescribed medication for a California resident, and then the California resident suicided. And when they did the tox screen, they detected the Prozac that the Colorado doctor had provided in the patient's in body. And so California then prosecuted the Colorado physician for practicing medicine in California, although the patient or the doctor had never been in California. And that case was upheld on appeal. So HAMAS is out there. It's being followed by other jurisdictions. But anytime we cross state lines with patients, especially with that first interaction, we may be committing a crime in that other jurisdiction, which is something we definitely want to stay away from. Shout out to Kara. Thanks for joining us as well. And then, so in addition to the lawsuit component, in addition to the possible criminal violation component, there's also the licensing board angle that we need to be mindful of. And I mentioned the emotional support angle letter. And again, the BBS is basically prosecuting a California therapist for writing that letter for a resident of Pennsylvania, right? DSM-5 diagnosis given in the letter, a lot of sort of foundational, sort of clinical information, and then the assertion of being, the person's therapist ongoing. It's interesting, I think where would complaints come from? And I think the ESA letter is kind of interesting about where the complaints actually did arise. The landlord who actually received the letter in Pennsylvania was the one who filed the complaint with the BBS because he didn't think that the letter was really supported by good clinical practices or legal practices. Another complaint with a bad emotional support animal letter was filed by an investigative reporter who did a story on how easy it is, to get one of these letters. So crossing lines, with providing, therapy services, problematic, licensing board angle, possible criminal violations, the lawsuit angle. And then some of our members will say, but wait a second, what about coaching? Coaching is unregulated. I can do coaching across state lines. There might not be a crime on coaching, and if it's truly a coaching relationship, the BBS probably wouldn't be as interested in that. But you still have the lawsuit angle. And if we're marketing services, right, in terms of coaching, you may have to defend that lawsuit in that other jurisdiction. All right, we've got a question from Andrea. Recent question about offering therapy internationally online. And that's really like throwing darts in the dark, because we have a basis for what Colorado's law is going to be. We can look that stuff up fairly readily. With international entities, we have no idea what their laws are, and that's always going to make the situation more problematic because we just don't have any basis for giving any sort of guidance. Sometimes they have laws, we might be violating them. We don't know what those laws are. Sometimes they don't have laws. On those sorts of cases, I think the best thing to do would probably contact the embassy and see if they can give you any help in understanding what the laws are. But that's a dicier case because we don't have a clue as to what their laws are or how to research them. All right, it's never, it's never wrong, right? Again, to address a crisis. I think that's regardless of where your patient, has traveled, you always have to deal with a crisis. If a patient, calls you and, we're concerned about imminent, suicidality, regardless of where they are, I think you want to handle that one. Fall back on the good standard of care, work, good assessment, evaluation, and management. I document in the notes, why we're doing the call, even though the patient is in, another state. We had a situation here a couple months ago where a therapist was concerned about a patient who had gone to Hawaii and was going to commit suicide, and they interacted, with the police in Hawaii to do a welfare check, and thankfully they did because the police got there and the sort of estimate was another 15 minutes to half an hour the patient would have died, right? So this is where we get locked into these, oh my gosh, they're in another state, I can't have any contact with them. And that's just not the way these laws have sort of rolled out over the years. You always want to deal with the crisis case regardless of where the patient is. And then we've got that follow-up care doctrine that would allow for some continuing interaction, right? Andrea, in response to my comments, it sounds like the California BBS wouldn't get involved then. They really wouldn't, because they're going to have less of a way of researching other countries' laws than we would. They're going to refer you to us in terms of whether to do it, but they possibly could get involved if the state or that other country finds that you committed a law in their jurisdiction. That's the thing. And when you renew your license, you've got to report any criminal things or violation things. So it could come out in the wash if we're violating another country's laws. The problem is we don't know what those laws are. Shane inquiring, what about receiving a lawyer's subpoena from another state? Disability application. Should a California MFT respond? Subpoenas are interesting. Most of you have the CPH policy. And one of the benefits of that policy is calling them. They'll assign you an attorney that will help you through the process, right? So with subpoena, there's a lot of issues that we got to look at. Is it valid? Validly prepared, validly served, limited waiver of the privilege, complete waiver of the privilege, do we have a waiver of the privilege? All that stuff would have to be looked at, but the best thing to do would be to contact CPH, get assigned an attorney who can help you through that process. Got a number of people sort of chiming in. That's awesome. Give us a little text. Let us know how you're doing and any questions. We have a few more minutes, right? But again, I think the key issue is the laws don't prohibit all contact with patients once they cross state lines. In addition to Wright v. Yackley, there's a famous case in California, Prince v. Urban. She was a California resident who had severe migraines, and she went back to Illinois to get treatment for the migraines. Did well, returned to California with a prescription, and she had follow-up communication with her Illinois doctors regarding her health. And then she started having bad side effects to the medication, to the point that she was so destabilized that she actually had to go into the hospital on a 5150. They did detoxed her. She got better. And then she tried to sue the Illinois doctors in California for malpractice. And remember, they had definitely practiced across state lines. They had prescribed medications, and they had interacted with her about how she was doing in terms of her care. And then applying the follow-up communication doctrine, the California court said you can't sue those physicians in California. If you're going to sue them, you're going to have to go to Illinois and do it. We don't think what they did was practicing medicine in California. We think it was just following up with an existing patient, which is something we want doctors to do. Shane asked, what if it's just a request for patient files? Well, with that sort of thing, we're always going to check with the patient in terms of getting the authorization. If they want you to authorize a disclosure of their file, that wouldn't be practicing across state lines or violating any telehealth laws. That's just responding to their request. If that has to go out of state, that has to go out of state. But we always want to get the authorization from the patient. Remember, good authorizations this day and age can be very broad or very narrow. They want the whole file sent, or just maybe a summary of the file. But get patient authorization; they'll help you with that one. Cara asks, would it be considered follow-up care to check in on a minor client's parent in another state? For example, joint custody issue. One parent in California, one in another state. Yeah, I think that would be okay, because we're not calling that person to do therapy with them. We're calling to get their buy-in in terms of the treatment of their minor child. So that's just decision making. I think that's always going to be fine. It raises a great issue, though, that I think probably needs to be vetted more at the licensing board angle. It's a fairly common call that we get. The kid, mom and dad divorced, the kid's struggling, and how much can we involve the parent who has moved to another state? I think that's an issue that at some point we gotta take a deeper look at when we review the regulations. But consent, that's going to be a whole different issue than simply doing therapy across state lines with that parent from another state. Consent's always going to be okay. There's lots of great articles at CAMFT about these subjects. I've got my next article in The Therapist is all about the jurisdictional issues, deeper dive in terms of the Wright case and the Urban case. There's an all-day seminar, 6-hour seminar, where CAMFT offers about telehealth sort of issues. Mike Griffin looks at the things you have to do to comply with the BBS's regulations. I do a 2-hour thing, getting deeper into these jurisdictional sorts of questions. And then Ann Tran does about 2 hours on HIPAA's security components and how they relate to this stuff, right? It's been a pleasure to spend this time with you. I hope you have a great Labor Day weekend, and we look forward to chatting with you on the phone about these issues in the future. Thank you.